by the sweat of your brow ye shall eat bread. Labor relations are very important. In fact, it's one of the few relationships that most of us will enter at least once in our lives. We identify by our jobs. We love our jobs. But what happens when our employers no longer want us in the workplace? When they're not paying benefits as they should? When we feel we ought to have more upward mobility? Where do you go? What remedies are available to you when your job no longer loves you? Find out on The Legal Brief. Welcome. This is The Legal Brief. We're going to be discussing labor issues, and to join me would be a partner at Harry B. Sands, Lebowski & Company, Lakeisha Strawn-Hanna, as well as Senior Associate with Higgs & Johnson, Keith Major. Welcome.
Thank you. Good evening.
We're going to get straight into it because we've been talking quite a bit, so we're going to get straight into the meat and potatoes of this. Contracts. Employment contracts, do they have to be in writing?
Right. So, no. The short answer is no.
Really?
You would be familiar with legal provisions that contracts, orally and or in writing, are both enforceable. We would recommend and prefer, as a matter of evidence, that they do be reduced in writing.
Right.
Because otherwise, parties that would be suing on the same would find themselves in a he say, she say kind of discussion.
Leaving a lot of wiggle room then to maneuver.
Right.
What say you?
I agree with Keith that contracts can be both in writing and made orally. But if the matter proceeds to court, then the best course for both the employer and the employee is to have all of the negotiated terms reduced to writing.
So if you're in a scenario whereby you do have something in writing, for instance, all of your remunerations and benefits, however, in practice, you're getting a little something extra, like gas money or gas allowance, the rest, or it could be anything along those lines. Would that be able to be incorporated or be said that that's a part of the contract?
Well, largely the court would look at custom and practice. That's typically the angle that the court would look at in those circumstances. What was the cost of dealing between the parties? And if it is in the wider terms, more that was reflected in writing, and that can be evidenced satisfactorily, then yes, it could be included.
Can go in the favor of the employee then.
Sure.
So if you was giving me a little something extra, I could get that when we go to court.
If there's some consistency to it, right?
To it.
About how long would I have to prove that you were doing this or giving this to me?
Well, when I say consistency, I mean in terms of there being some measurable frequency. Not, well, maybe on a Monday I might get something. It's something I can look at every Monday or every
so once it's fixed, I'm sure that it's coming.
Consistent,
Correct.
then you can rely on it as a term of your employment per se.
Okay, so that's good. That's good to know. Now, going further, so contracts can be both in writing or oral. I understand that. Now, let's talk about this probationary period. This seems to be a real sticking issue. In law, what's a probationary period?
So there is no fixed probationary period in the Employment Act. Again, that is by contract and negotiations between the parties. But we would know that the standard or maybe normal probationary period is 3 months or 90 days. However, that can be extended by consent of both parties.
So both parties have to agree that it goes beyond 90 days.
Correct. And you would usually agree that during the contract signing phase of the employment engagement. So at the beginning, you would iron out the issue with regard to probation.
I think you're talking about in a perfect world. We're talking about now home here in New Providence.
And like we initially stated,
He laughed because he knows where I'm coming to you.
like we initially stated, contracts can be both in writing and made orally. So after the contract has been reduced to writing at the initial stages of the employment engagement, later on, the parties can decide, that's both the employer and the employee, they can decide that I will allow my probation to be extended for a further 2 months, 3 months, whatever period the parties agree, and the courts would enforce that.
I'm finding, particularly persons who work in larger corporations or institutions or for government, that you find that their temporary employment extends sometimes years. Would so can that and of course the employee is not asked anything. Nobody calls you in government and say, "Oh, do you agree to be temporary for another 3-5 years?" So is it then, let's say that person for some reason is terminated after 3 years and they're told, well, they're told they're not permanent or pensionable. Can they argue that in fact they are?
Well, I don't know if I'll go that far.
How far would you go?
I think there are some decided cases that hold that fixed term contracts, successive fixed term contracts, would be deemed to be continuous employment for the purposes of Section 29 and termination with notice. So
And that's Section 29 of the Employment Act.
that's Section 29 of the Employment Act.
Okay.
And so there are some decided cases. So they are not without any relief. Now, when we talk about jumping to permanent and pensionable, I think that's a leap too far.
Really?
I don't know if they'll be able to close that gap.
Correct.
But I mean, come on. If I'm hearing you correctly, Ms. Strawn, I've been working now continuously for 2 years, 3 years. I mean, it can't certainly be considered temporary.
Well, the Employment Act doesn't differentiate between what we call temporary or maybe a part-time employment versus a full-time employment. So once you are employed, you are entitled to all of the benefits, and that's the minimum benefits outlined in the Employment Act. So you could be employed for 3 years, and your employer may categorize you as temporary. However, if you were terminated, you are entitled to all of the benefits as a full-time employee and all of the benefits under your contract or the Employment Act.
So then we've naturally come to that. Then explain that. What would the benefits be? Not just broadly. How is it calculated? You work for 3 years. Is it different if I am, let's say, not a manager, just a line staff? Is there a difference in the law how I ought to be compensated?
Correct. So usually it's outlined in your contract what you're entitled to upon termination, but the minimum amount upon which an employer must not go is that is outlined in Section 29 of the Employment Act. So if you have been employed for at least 6 months and you are dismissed without cause, and without cause I mean without a reason, for no reason, the employer just decides, well, you know what, this relationship isn't working out.
I just don't like you.
Correct. And I think we need to part ways. Right. And I think we need to part ways. Then the Employment Act allows an employer to dismiss you without cause, but you have to be given notice and what we term severance pay. Even though the Employment Act does not use the word severance, that is the term we use for years of service. So we call that severance pay. So if you've been employed for at least 6 months, then you're entitled to 1 week's basic pay. And to understand what basic pay is, that's just your flat pay without any commissions, without any tips, without any gratuities. So you're entitled to 1 week basic pay. And when you have been employed for any time between 6 months and 12 months, then you're entitled to the prorated of 2 weeks between that 6 months and 12 months.
2 weeks.
Correct.
Now, is that
Prorated.
1 week for each year?
No. So when you're employed for under 12 months, but the time period is between 6 and 12 months, you're entitled to 1 week's basic pay.
Just 1 week?
1 week. And then you're entitled to 2 weeks prorated, and let me be sure.
Yeah.
2 weeks
What about
prorated.
notice? So notice pay, do you get it?
So the notice pay is 1 week's 1 week's
1
pay.
week.
1 week.
So 1
basic
week pay, basic pay, and then 1 week notice.
Okay, and so when you've been employed for 6 months or more, but less than 12 months, then it's 1 1 week's basic pay for the period between 6 months and 12 months.
Oh, wow.
Yeah.
That's it.
That's it. But that's only when you've been employed for less than 12 months. So when you've been employed for more than 12 months and you're a line staff, you're entitled to 2 weeks basic pay and 2 weeks for every year up to 24 weeks.
I can see it. I can feel it. Grand Bahama, the bounce back. You had a clear vision.
Yeah.
What is it that you hope this show will do for the island of Grand Bahama and indeed the people here on this northern island?
It will do exactly what bad news does. It reverses that and let people know that all hope is not lost.
In the person of the Honorable Prime Minister Philip Brave Davis, right? He's doing an excellent job.
I'm seeing major hotels. I'm seeing large cultural shows.
It's time for us to actually invest before we can ask someone to invest.
There's a greater good and there is something bigger than me and you.
Coming this fall, The Bounce Back, only on the ZNS Network.
Welcome back to the Legal Brief. Just before the break, we were discussing compensation or natural progression when persons are leading up to termination, and it's, of course, compensation that's included in that. And I was saying about suspensions, whether they should be with pay or without pay. And I think Mr. Major was saying that it's not in the act.
Right.
And so I think, again, Ms. Hannah, you bounced back and said, well, it's the natural progression in terms of once you move from oral and verbal to written, it's natural that there should be a suspension.
I agree with what Keith had said, that the progressive discipline approach is not enshrined in the Employment Act. But I think it naturally occurs in an employment relationship because if an employee commits an infraction, an employer would naturally go to that employee and say, well, hey, you're late or you're not clocking in. The employer would naturally go and warn that employee about their behavior.
Although it's not written strictly.
Correct. So that can be an oral or written warning. And if that employee continues to commit that infraction, then the employer may decide, well, hey, I've been warning you orally and in writing and nothing has happened. So you know what? Now I'm going to suspend you.
Go home.
Right. Well, suspend. But here's the tricky part. An employer can only suspend without pay if that is written in the contract. Because again, there is no suspension in the Employment Act, and there's definitely no suspension without pay. So an employer can only suspend an employee without pay if that is written in their contract. However, an employer can suspend with pay as a part of their progressive discipline approach.
Okay, so that's good to know. And I still can't get over the compensation part of it, because I'm thinking about the weeks that you say up, if you're a line staff, up to 24 weeks, if you are management, 48 weeks. What about compensation to how long would it take me to get comparable employment? Pay for that over and above the 24 or 48 weeks. What are your thoughts on that?
Well, in my opinion, the compensation for termination without cause, which is the 6 months or the 12 months, is to assist you, or it contemplates your salary, your basic pay, for being out of a job, right, for 6 months or 12 months. So during that time, you should be actively looking for new employment. So those funds are to assist you while you are unemployed. As Keith said, those funds are not for you to go shopping in Miami or Fort Lauderdale or Orlando. They are to assist you with the payment of your bills, whatever obligations you have during your period of
Somebody's
unemployment.
television just broke. I know it just broke.
Yeah,
Do
so
you
that's what
agree
it
with
is.
this?
Yes, so that's what it is.
I mean, practically speaking, though, when you get that check, I mean, already there's so many bills and other things that you have to deal with. And let's say, and again, we're talking about the process of termination. You talk about the natural progression. You terminate me and you give me this check, but then there's so many other things that have to happen. And then too, I have to be looking for a job whilst this money is there. And you've inconvenienced me greatly.
Correct. And some employers, when they realize that, they give an ex gratia payment on top of the minimum amount that you're entitled to under the Employment Act. But also, national insurance now has unemployment benefits.
Oh, please.
So that's kind of a added compensation.
That's for a whole nother show. NIB. Whole nother show.
But that's added compensation. So,
And it's 13 weeks.
correct.
I want you to touch on Mr. Major and you as well, Miss Hannah. What process? What should I do if I'm terminated and I feel that I've been wrongfully terminated? Where do I go? What should I do?
Well, there are a number of steps, and again, it depends on which organization you're employed with. Some organizations have an internal appeal process where you could lodge a grievance in around. It doesn't even have to be termination. It could be something during the course of your employment that you feel
I shouldn't have been punished or something,
right.
or suspended.
So it depends if your organization has that mechanism. Outside of that, you may be in an organization which is unionized, and you might have an industrial regime or a collective bargaining agreement which speaks about a grievance procedure that you should follow.
Okay.
If it is that your employment should come to an end. So it depends on that. Outside of that, you have two, I guess, main avenues or forums that I would like to call them. One, the Labor Board / Industrial Tribunal Forum, and two, the Supreme Court. So if you go to the Labor Board, you're able to file a trade dispute, which is known as a trade dispute, and that needs to take place within 12 months of the event upon which you want to complain about, that you've been aggrieved about. Once that is taken place, a conciliation notice would be issued to your former employer and to you for you to attend before the Labor Board, before a conciliator, for you all to have a discussion just like kind of like.
Does the Labor Board have teeth?
Well,
why? Wait, I'm sure you heard that pause. You saw that because I certainly did. Ms. Hannah, does it have teeth?
What I can say is they do their best to try and mediate and bring some amicable resolution to the matter.
Do the parties have to appear? Does the employer have to appear at the Labor Board?
The employer has to appear at the Labor Board.
And if they don't?
Then I think there'd be sanctions, correct.
Okay.
So they have teeth in that regard.
In that regard.
Baby.
But you heard it here, baby teeth. And so thereafter they appear, do they have to take the recommendation of the Labor Board?
There is no requirement that they do, but they should, because you go there in good faith trying to resolve the matter. So, and most times when employers go, they have their counsel with them. So if the advice of their counsel aligns with the advice of the conciliator, then I think they'll go ahead and they'll take the advice, and the matter would be resolved. But there is no obligation on the employer.
But I think that's problematic, because I've had many instances where employees would say, I want my matter at the Labor Board, but there's nothing to win at the Labor Board.
Correct. There's nothing to win.
So I think sometimes people get confused.
They think that the Labor Board could force the employer to pay them or to rectify or give them some type of redress. But I want to know what are the pros and cons in terms of going the conciliatory route through the Labor Board versus the Supreme Court? Who wants to take that?
Correct.
Say cost?
It is cost. Because if the matter is not resolved at the Department of Labor, then the applicant has the option of having it transferred to the Industrial Tribunal. And once you're at the Industrial Tribunal, if you lose, there's no order for costs. So each party bears their own costs at the Industrial Tribunal. However, if you go the Supreme Court route, and if you lose, then the judges have a discretion, but more often than not, you would be responsible for paying the other party's costs, your employer's costs. So we find that most employees take the route of the conciliatory process at the Department of Labor, and they thereafter have their matters transferred to the industrial tribunal if there's no resolution at the Department of Labor.
I think time as well is another factor. I think it moves fairly quickly through the industrial tribunal. No, you haven't found that? Arguably?
I think the industrial tribunal has been doing, making great strides lately with regard to the hearing of the matters. Before President Indira Francis was made president, there was a backlog of cases. But we see now that the industrial tribunal, they are hearing a lot more cases, and the cases are moving a lot quickly.
Are you throwing kudos out to her?
But I'm saying the obvious, and I'm saying facts. So I can say right now that they're doing,
according
there
to
are 4 judges now that sit for vice president.
No, I must concur. I find that they move fairly quickly once the recommendation is sent from the labor board, that the process moves.
So it's moving a lot quicker than it would in the past.
It's been modernized, right?
Correct.
It's now digital.
Digital, correct. Yes. So you file all of your documents online, and you just do everything online rather than having to physically walk.
Walk over and
correct and file documents. You can just sign on to the attaché and view all of your cases and all of your documents from the comfort of your home or in the front of any computer.
That's excellent. Redundancy. We're going to touch that when we return. Redundancy, because I think people use that to get away. You agree, don't you? He's smiling because he represents those people. We'll continue discussing this issue when we return on the Legal Brief.
Welcome to a world of art, a world of entertainment, and a kaleidoscope of cultural expression. It's a new season of A&E Showcase. Allow us to take you on a journey and introduce you to the talented artists, musicians, and creatives who share their incredible stories. A&E Showcase. Watch it on the ZNS network this fall.
So you touched, Ms. Hannah, you touched on termination without cause. I want to learn more from both of you. What is the process that an employer should follow when they wish to terminate an employee? I think everybody wants to know, because it seems to be so ad hoc, the way that people behave. Is there a process? And if so, what is it? Mr. Major?
Yeah, so I think it depends on the mode of termination that we're looking at, right? So as Lakeisha mentioned, you have with cause or without cause terminations. Mm-hmm. Without cause terminations are the most simplest species, right? You can indicate to the employee, thank you for your years of service. We no longer need your services at this time.
You're being quite polite because we know what kind of words they use, yeah? But it's understandable. He's being polite, but he knows what they tell you, what to carry and what to... But we ain't going to go there today. Well, today...
Indicate we might need you to turn over your uniform, your badge, all those other things that belong to the company.
Give me my things.
And, here's the breakdown of the funds that are your just entitlement under the law.
So before you get to that point, well, like you're saying, without cause, you can do that.
That's without cause. And employers are able to do that. They're entitled to do that because they're, in that instance, paying you either with notice, as Lakeisha mentioned, or with pay in lieu of notice.
I want to know from both of you, I'm going to start off with you, Ms. Hannah. When you decide that you want to let me go without cause, should my check be waiting for me right then and there? You tell me, leave your premises. Should you have my check in hand?
You should. The employee should have the employee's check at the date of the termination. Now, the Employment Act doesn't mandate that for termination without cause for redundancy. The employee is entitled to have their funds at the date that they're being made redundant. But we find that the normal practice is for employers to have the termination check available and ready for the employee at the date of termination.
Now, what about this scenario? And I hear it a lot that, okay, you're terminated without cause. And then when you go to the office, they thrust a paper in front of you and telling you, oh, you have to sign this. If you don't sign this, you can't get your check. Now, come on. You know, that's like insult to injury. Just give me my money.
Right.
Employees can try it, but it's not mandatory for employees to sign what we would know to be deed of releases. So no, there's no
So you don't
obligation.
have to do that.
No, there's no obligation on the employee to sign the deed of release.
So you're hearing it here from a partner at Harry B. Sands. Do I get a concurrence from Higgs and Johnson?
Yes.
So there you go.
Yes.
No one can force you to sign these deeds of releases.
Correct.
Just give me my funds and let me go.
Correct.
Okay.
But as a matter of negotiation.
Correct.
Okay. Always. Come
Let's
on.
be
Oh,
honest.
yeah. Come on.
It is open to an employer to provide what we call an ex gratia payment, a payment that is not a just entitlement, to bind what we call a deed of release, would be a sum on top of your just
Break that down
entitlements.
for us.
So let's say, as Lakeisha mentioned, your notice pay would work out to be $2,000.
Yes.
You're entitled to that, whether it's wrongful or not.
Right.
If we want, when I say we, because sorry, as a matter of force, I typically represent employers. Sometimes I represent employees.
What persons may be thinking the enemy? Go ahead. It's a necessary evil, but most watching thinking, yeah, go ahead. Okay. Yeah.
If the employer in that instance wanted to insulate themselves from litigation, they would advance what we call an ex gratia payment, which is a payment on top of the notice pay. So let's say another 500 or 600 or whatever.
That's so that you don't sue them.
To be consideration for this deed of waive and release. If it's acceptable to the employee that's being released, that document would be upholding and binding, and it would prevent further litigation. Because who wants to go through that, right?
Oh my goodness. Can the employee, well, I guess you would say yes, so they can negotiate for that to go up. But I want to know this. We've talked about without cause. Now, with cause, is there a process that should be followed? Or can an employer just wake up one day and say, I'm terminating you with cause? Is there a process?
You want to deal with that?
Well, there is a process that employers should follow if they're going to dismiss for cause. And enshrined in any employment contract is the right for natural justice, and that's the right to know why you are being dismissed. And usually before a dismissal, there would be warning signs, and you would get warnings. So the employer would warn you orally or in writing about whatever infraction is occurring. And after the oral or written warnings, then you may have suspension. And then depending on the nature of the infraction, they may go straight to suspension and then dismissal. And then for what we call major breaches of conduct, the employer can bypass what we call progressive discipline of the written warnings and the suspension. And then they can go straight to termination. But it all depends on the circumstances and the particular infraction that will dictate which course is to be followed.
So I hear you. I want you now, if you can, should an employer give me, let's say, 2 warning letters in one day? I mean, that's, come on. It seems a bit, and you know it happens. Like when they want to get, I hate to say that, it's perception that they want to get rid of you. And so they start knocking it up, like trying to set the stage. Oh, I've warned you twice today, and now you get written warnings 2 in a day. Should that be?
I think I have to give the lawyer's answer, though. It depends.
Correct.
Oh.
Because what if the employee commits an infraction in the morning, and they get a warning for that, and then they do another infraction the very same day? I could see that as plausible, right? Now, I don't know, exact, facts you're talking about. I don't know what you think about that.
I agree. And an employee can get several warnings, written and oral warnings, in a day for the same infraction or for multiple infractions.
But it has to be, you would agree, it should be separate instances.
Correct.
It shouldn't be the same instance.
I agree. It has to be separate instances, because if you're giving several warnings in the same day for the same infraction or for the same...
It shouldn't count as a different warning.
Correct.
It's the same
No,
warning.
correct. And I agree with you. It should not count.
Okay.
and will definitely be seen as
So you're smiling
employer.
because both of you smiling because I think you try to justify these actions when they do that, eh? These corporations.
No, we try to when we give advice. When we give advice to our clients, we give advice to prevent them from having to go to court. So, and we encourage them to follow the right procedure.
Right.
So, as we are stating here, we would say, well, if it's the same infraction, you don't give 2 warnings for that infraction, because if the matter proceeds to court, the court would not see that as 2 infractions or 2 different warnings. Right. The court would only view that as 1 warning.
Right.
So it doesn't do any justice to the employer to pad or to give multiple warnings for the same infraction, because at the end of the day, it doesn't assist their case. So give warnings when they're warranted.
And 2, now I hear you, verbal warnings, you should have oral or verbal warnings, then it should progress then to written warnings. And then you said suspensions. I want to know, suspensions, can there be suspensions without pay? Or should suspensions be with pay?
Well, I just want to step back a bit. In terms of the progressive discipline that Lakeisha mentioned, that's not statutorily prescribed.
Correct.
I think what she's talking about is best practices.
It is not.
Okay.
So I just want my employers watching to know that that's a sort of fetter that they have to carry. And so in some instances, as Lakeisha mentioned, the act that we are trying to address may be so egregious that you don't even have to go through a verbal or written warning. You can just go ahead and take some more strenuous and potent steps.
We can stick a pin right there. Don't worry, I'm fighting for you. I'm fighting for the employee.
Yes.
We're going to come back and touch this further on the legal brief.
You're not going to do very well in this court if you keep cutting me off.
I've already paid him $500, and I noticed we haven't spoken about the $500 that I paid him.
I did not receive any of my money.
I didn't know her like that.
I ask the question and then you answer.
But I spent that on my car.
Mr. Rowe, that is the order.
I joined an ASU that was led by Mr. Wilkinson. At the end of it, I would have received $5,000. However, I did not receive any of my money.
You would understand the importance of a wedding day for a bride.
Well, I've never been a bride.
The decision is legally binding.
All right.
The legal brief, it seems as if, and I don't know why these guests just go at it when you're not watching, but we're having a very heated discussion about redundancies. And I'm just going to put it out there. I feel as if it's abused, that employers use it to clean house by saying, I'm making positions redundant, or I'm going to bring back someone at a certain point or a group of persons, and yet they cherry pick. Explain to us, what's redundancy?
So a redundancy is apparent or exists when an employer has decided to cease operations in a jurisdiction, or at least a part of a jurisdiction, or there's a diminution in work that requires it to have any employees of a certain type or a certain amount of employees for a certain type. That's the strict definition of redundancy. Now, I think what you've referred to, and what many people, I guess,
what we know commonly here in the Bahamas, in Nassau,
would be what we call a sham redundancy. Mm-hmm. Many people believe that redundancies are shams, and that's the way to get rid of someone who has been a troublesome employee. They didn't want to fire them for cause or risk.
You, Ms. Hannah, because you know your employee, your clients do it, yeah.
But I find that when we approach the subject, it is always justified, right?
Correct.
I can't believe that.
Invariably.
I agree. So the individuals are our clients, as far as I am aware, and we have genuine redundancies. There is either a decrease in the business either closes down, or a location closes, or the number of employees that are needed to do a particular type of work decreases. And in those instances, employees are made redundant.
But you know what is also, I think, controversial though, Lakeisha? You want me to say it? Lakeisha, Ramona. How are employees selected? I think that's always a bone of contention. That also is not statutorily prescribed.
Correct. It's not.
There's a
So,
usual
so therefore, there's no protect. They can bring back who they want to bring back.
No, well, when I say that, I mean in terms of who they select for redundancy.
Exactly.
Right?
So, but there are different factors that an employer has to consider when they are deciding which of their employees should be made redundant. Yes. So they look at job performance, they look at attendance, they look at tenure.
They look at experience in the workplace, who's holding their feet to the fire, and you need to go first.
No. But there are different criteria that the employer should consider when deciding which employees will be made redundant.
And
now,
both statements can be true, right?
Correct.
You can have someone who's problematic and someone who needs to go.
And if there is a requirement for that particular job function to be reduced or eliminated completely, then that employee will be made redundant. It's just coincidental that that was a problematic employee.
Just pure coincidence.
But that doesn't mean that the redundancy itself is a sham.
And so, but I'm always taken aback by, okay, you say that you need to downsize, but yet you have workers, the workers who are left, you then make them do the work where you sent persons home. So then I'm wondering, well, why did you need to downsize if you then double up on the tasks or duties to those who are left? And many times the same pay.
Well, you know, I guess...
And it happened.
I guess my response to that would be in terms of right-sizing the business and managing its expenses against its efficiency.
You just want more profit.
But I think every business is...
but at the expense of whom?
Well, I don't know if I see it as a zero-sum equation.
How do you see it, Mr.
I think a high tide lifts all boats.
Be careful with that.
I think all employers...
I hope you're hearing this talk. I'm an attorney as well, but I'm hearing these things for the first time. Yeah, go ahead.
And I think all employers have a right to manage their business in the most effective and efficient way. So at the end
of the expense of the employee.
So it's not really at the expense of the employee, because at the end of the day, if they are eliminating a particular job function, or they're reducing the amount of employees, those employees that are made redundant, they will be paid. So it's not as if they're going home empty-handed.
So
they will be compensated. And if within 12 months after having been made redundant, if the employer is going to, I guess, expand that particular job function again or open up that business, then those employees that would have been made redundant, they are first priority in terms of bringing them back on the job. So,
however, don't tell me there's no fixed rule as to that they have to rehire them. They're just first in line for consideration.
That's a statutory mandate.
They have to be rehired?
Correct. With the amendment of the Employment Act in 2017. Okay. That's a statutory mandate that those employees that were made redundant within the 12-month period, they have priority over any new employees.
Okay. So compensation, is there a formula as with termination for redundancy? And
it mirrors actually the payment that you would get under Section 29 that we discussed earlier.
Listen, one thing I'm getting from this, from both of you, and it's been very informative, is the need for reform, further amendments to our Employment Act. Do you agree that we need to have further amendments, or do you feel outright repeal the entire thing and let's start all over?
In my opinion, there's no need to repeal the entire act, because as can be gleaned from the amendment to the 2017 Act, where there are any deficiencies, there's always the right to amend, and that is what was done. However, I think a problem that constantly arises in the employment arena is the matter of retirement. The Employment Act does not prescribe a retirement age for employees. So that's purely by contract. So I think...
So it's not 65?
No. And it all depends on what you negotiated with your employer. And if there is no retirement age, then you're entitled to work until you cannot work anymore, until you either leave or you're terminated.
And I think we were discussing earlier before we even began about this whole issue of retirement, that is so, you work 30, 40 years and you leave and you get nothing. And I think you thought that was okay.
Okay, I wouldn't necessarily say okay.
Definitely. I think both of them thought, oh, what do you want to get?
Okay. Yes. My position is that you worked 40 years. And to be fair to your employer, during those 40 years, your employer paid you for working. So it wasn't as if at the end of those 40 years, you are necessarily entitled to more monies because you need to find another job. You're retired. So what the employer should do, and this is what can be another reform or another amendment to the Employment Act, is to enshrine a provision with regard to pensions or gratuities. Make it mandatory that upon retirement, that there is a pension fund or gratuity that is available to an employee.
Particularly if you see the person is going, let's say, over 15 years.
Correct.
That something should kick in.
Correct. So it could be, I guess, generally the Employment Act can mandate, well, hey, employers and employees, they shall have a pension fund, and after 5 years or whatever is negotiated between the parties, it is invested. It is vested. But I think that's a reform that is reform to the Employment Act that is definitely needed. And I just don't think we should place the obligation on the employer to ensure that the employee has funds upon which to retire upon their retirement date.
Come on, now you're being a bit heartless, Ms. Anna.
No.
Mr. Major, come on. Rescue the retired. Come on now.
But,
throw them, like you said, right? High tide, everybody wants to float.
Right.
40 years, I've been working. How could it just be not even a luncheon or just a fruit basket?
You could get a luncheon or fruit basket, but to say that your employer has to give you 1 year's salary upon your retirement, I think that's stretching it a bit. I think, and that is why if there's a retirement or a pension plan or some gratuity that was established well early in your employment life, then by the time you retire, you would have that nest egg that you're looking for. Because let's be honest, even if your employer gives you this payment of 1 year's salary at the age of 60 or 65, whatever the retirement age is, how long would that last?
It's something because, of course, you're going to get national insurance.
Right, but whereas if early on in your employment, both the employer and the employee planned for retirement, and there's a pension fund established, then at the end of that 40 years, instead of that 1 year salary that you have, you can have 10 years salary, 20 years salary, whatever the amounts would be.
I agree.
So I think at the end of the day, it serves a better purpose for a pension plan or gratuity to be established rather than saying the employer must provide a lump sum payment at the end of retirement.
So I take it you both agree there should be some amendment to make something mandatory at a certain point.
I don't know if I go that far. I don't know if I go that far. Only because, when we look at it from a holistic standpoint, many employers in the economy are small to medium enterprises, SMEs. I wonder, again, as I, spoke earlier in terms of the burden that you place on employers, would you have the unintended consequence of causing persons not to hire persons because of
or let them go when they reach a certain, or you're about to hit that 15-year mark, I gotta let you go because I can't afford you.
So
it's something to consider. But also talking about the probationary period that's not been stipulated, I believe there needs to be some amendment there. Do you both agree?
Well, I disagree with regard to probation. Probationary period being enshrined in the Employment Act, because I think it all depends, because job titles differ and it all depends on your job function and how long.
You should know. If you keep me for 3 months.
And it's negotiated. It's negotiated.
Isn't like dating. If I date after a certain point.
Exactly, then if it isn't working, you let them go.
I should be able, it's just like if I'm dating you now a year, I should be able to call you my boyfriend, right?
I see,
so therefore I should be able to say I'm permanent.
Correct. Well, if someone has been working for a year and they're still on probation, then I think they need to sit down with their employer and have a serious conversation.
Oh, true. You're hearing it, right? Oh, wow. Okay. So, reform, we've talked about retirement, probationary periods. Is there any other areas you think for reform?
Not reform, but I think it's important to point out the provisions with regard to layoff, because I think a lot of persons are confused. Lay persons use layoff to mean termination, but us as counsel and attorneys, we know the term layoff to mean you're out of work for whatever period of time without pay. And with the 2017 amendment to the Employment Act, that allowed employers to lay off, that means send their employees home without pay for a certain period of time. Now, after I think it is 12 weeks, 13 weeks, after 13 weeks, if you've been laid off and you haven't returned to work, then that is considered to be a redundancy, automatic redundancy.
Is this what became very applicable during COVID? The person started during COVID. I guess people didn't expect it to last that long. I see you both being very cautious. Oh, wait, no, we're going to start with you, Mr.
Well, a couple of things. You know, it was implemented before COVID.
Correct.
I don't think that when it was implemented, it was envisioned that something to the magnitude of COVID
would happen, but it was sort of utilized.
It was
by the employer.
But then you also have to remember that special provisions were enacted, which caused those provisions of the Employment Act to be told or stayed, as it were. So they weren't effective. So many persons, and I think especially in the hospitality industry, complained about that because they were able to exist in a state of
limbo, not knowing.
Furlough and layoff in excess of 13 weeks. And some of them was clamoring, just give me my redundancy pay and let me go. But
because of course your bills are racking up and you're not receiving the remuneration.
But I think there's something to be said about keeping tenure. I mean, I know it was a painful time and I get it. And anytime an employer has to separate from an employee, it is somewhat traumatic, right? Because your employment is sometimes a part of your identity. And so I get it. But there are some rules in there, and I think there's a balancing act,
And there has to be a balancing act between the employer, the employer and the employee. There has to be.
Right.
And I think during COVID, I think that is what was attempted with the suspension of the redundancy provision.
Right.
Because like Keith said, your tenure remained continuous. So that means you still continue to accrue benefits. It's just that you remained out of work for a longer period of time than you normally would have. But at the same time, many of the employers had to shut down, some closed, and many lost a lot of business. So I think that was probably a way of trying to strike a balance between the interests of both the employer and also the employees.
An increase to these minimums, 20, 24 weeks, 48 weeks. Should it be increased? I mean, looking at the cost of living is gone up tremendously. I think we all feel it here. I guess maybe because of COVID and the difficulty they say in items being brought in. I mean, there are numerous factors that play a role, but should that be increased?
I can say most definitely that during the discussions before the Employment Act was passed, I sat in many of those discussions, and most employee advocates, they advocated for an increase in those time periods.
Right.
However, that was not approved, and we retained.
I guess people like Mr. Major knocked that down.
Well, I don't know if it was Mr. Major, but we retained the 24 weeks, correct, in the 48. The other Caribbean jurisdictions, they give higher time periods or compensation, but we remained with what was in the Employment Act of 2021. But I mean, that's always open for discussion again. It can be brought back to the table, and then again, it's up to Parliament to pass the law.
Yep.
That's right.
I think the Employment Act has proven to be a very durable document, don't you think? 20 years plus.
I have to agree with you. It's a good starting point. I would have hoped that we've been further along, and that certainly the remuneration for timetables or how it's worked out would move closer to the realities that we're faced with. But overall, it's workable, and this certainly has been very enlightening and educational. Learning about the very contracts, employment contracts, we've run the gamut, finding out that they can be in writing, verbal. Certainly, I know many people were enlightened to find out about redundancies and that they're entitled to pay, and that, you can be suspended, but not without pay unless it's written. So it's just so much that we've learned. And I have to say, thank you to you both, Lakeisha Strong and Mr. Keith Major. You held back a lot. So no doubt we're going to have a part 2 because we've left so much untouched. Yes. This area is just so broad. Yes, it's vast. But thank you so much for joining me. It's been a pleasure.
Same here.
The laborer's worth is higher. We've been fortunate to spend an hour to discuss the Employment Act, and we've dwelled into that to know about contracts, whether they have to be in writing, whether they can be verbal. We've learned that they can be both. You've also been informed as to what you can expect if in fact you're terminated, if you're a line staff, if you're a manager. But most importantly, you've found out and you've been educated as to what redress is available there, which avenues you can take, what are the pros and the cons. At the end of the day, we recognize how important your work is to you. Work is to everyone, to our country. And we at the Legal Brief wish to inform you as to where and what and how you can make it better. I'm Ramona Farquharson, and this is the Legal Brief.